I thought.
For what?
This is the case where my arguments have been closed without hearing me.
No, we didn't want to add that.
No, why? The hearing is tomorrow.
We are not giving liberty to move the High Court. If you have that liberty, you can take that liberty. We don't want to create that space.
With the dismissal order, it will become difficult for me.
Maybe withdraw, but now we've passed the order yesterday.
No, that's. I made a request yesterday before.
But we don't want to give you liberty because the High Court has closed your right to argue because they felt that the lawyer had never cooperated with the High Court, didn't want to argue the matter, and they said, okay, we are hearing the others.
I'm sorry, but I was not there at that time. I was in another court. Actually, we had finished arguments before another bench. Then this was another bench.
I pointed out to the High Court.
If my lord doesn't give me that one line.
It's not necessarily the High Court. To allow somebody to be heard, you don't require a direction from the High Court.
What they did is they fixed a date for the state.
Right. So
state also sought an adjournment.
But before the state argues,
this
does not preclude you from telling the High Court, I want to take 5 minutes to just argue it or tender a written submission to the High Court. There are so many things which can be.
Would my lord consider writing?
Not necessary, Mr. Ganthanan.
May please, my lord.
May I please mention item
May please,
7?
your lordships.
May I please mention item 7?
May.
Because that's the.
We'll keep it tomorrow because this will take us through the day today.
Yes. Milos, may I make a request on item 7? That's the matter fixed for today. The visually impaired, the Madhya Pradesh matter. I am the candidate. The larger issues, there's 7. I am 7.1. Milos, the difficulties which my lords appreciated, the result will be declared.
What do you want right now? We're in the midst of a matter.
Yes, Milos, I am only requesting for tomorrow because it's unlikely.
Yes, Kala.
Right.
10 is which matter? This one. Don't make any requests in any going on matter. We'll hear it. Whoever is here, we'll hear them. Otherwise, we'll conclude our argument today and we'll conclude it. That's it. Sorry, not at all. Whoever is here today. Be ready here.
Will your lordship be taking our matter first tomorrow?
Yes.
Deeply obliged.
Which has been filed, my lord, registered, my lord. Same
These matters will keep on coming. Whoever is here today, we'll conclude it today. Yes.
I'll give you the diary number also.
Get it verified, registered, etc. Yes. Yes, Mr. Ranjit Kumar.
Lordship is grateful. But what I was pointing out about our CA 154, our lawyer, your lordship mentioned, Mr. Lyrie is here also. Unfortunately, he happens to be here, who was there before the High Court.
Yes.
Mr. Lyrie informed me that everything was placed. Only this has been noted in paragraph 108. And he also informed me that some written submissions were also filed before the division bench, pointing out all these facts about us.
So what happens if you lose your job now? Then will you retain your lien earlier or not?
That's why we have annexed the rules. We had filed an IA also in the main petition,
Yes.
which is listed today, 109747.
So when you accepted this job, you lost your lien.
Yes, I've lost my lien, the rules are there. If your lordship permit me,
So you basically sail with everybody else ultimately. There's nothing special in your case. You sail with everybody else then.
The special is this, that I came here for a better job, in the sense better prospect, and for no financial implication, continuity of service. Some people are to retire next year. Some people will not have been appointed in 99.
Before the High Court was segregation.
Sorry, Lord.
You argued segregation before the High Court.
Yes, my lord. And my lord, if your lordship sees the High Court judgment, kindly, my lord, permit me the 3 options which the High Court itself notes. At page 250 in the main petition, my lord, or even in my petition, page 250.
Yes.
Sorry, my lord. Just give me 1 moment. One second, my lord, please. The High Court notes that there are 3 options before the High Court, and that your lordship will find at page number, my lord, 255 lot of the paper book, which is paragraph number 312. PDF page 295. At the
Yes.
foot of the page 312.
In the main act.
Dismiss the writ petition, my lord.
Yes.
Dismiss the writ petitions on the ground of maintainability or explore the possibility of segregating the valid appointment from the illegal one or set aside the selection made in the selection process in the entirety.
Yes.
So the High Court did have kept these three options, my lord, in mind. And then, my lord, if your lordship see below that, first option noted above is no longer available in view of the decision rendered on the issue of maintainability. That is on the limitation part, etc., that people came to the British court after, my lord, the expiry of the panel and 3 years after the appointments had been made.
Yes.
And then on the second option, my lord, the consideration starts from page 314, para 314, and if your lordship will kindly come on this aspect at page number, what they say, my lord, in para 321 and then 323. In respect of, my lord, in respect of the four categories of the selection process involved, written examination has been held. Written examination in the form of OMR sheet. Original OMR sheets have been destroyed. Mirror image of the destroyed OMR sheet was required to have been preserved. CDI had seized the server of SSC and did not find any mirror image of such OMR sheets. So SSC and authority within the meaning, etc. I'll skip that. Now kindly come to 323. See, significantly, it is a claim of the SSC that scanning of the OMR sheets had taken place at the office. If that be so, then SSC had knowingly allowed another organization to scan the OMR sheets, namely so and so, who was not authorized. This raises serious questions as to the integrity, sanctity, and validity of the entire selection process and going to the root of the system. So this is the basis for not segregating, my lord. The second option, not opting for the second thing, that whether we can segregate. And then 260, para 330 onward, the third option is considered thereafter. So I am respectfully submitting, my lord, that I am not in any CBI list. There is nothing, no such thing against me. There are government orders. I have. At page 703 in my paper book, in my 17.6 item, we have annexed the pay protection granted by the government, and the carry forward of the service book is at page 705. 703, statement of protection, and thereafter approval of that fixation of pay and protection by a superior authority, and then the service books are from 705. We have annexed one of them because there are 367 people we have, and that's why we have put it in a chart. So it shows, my lord, memo of 2008 at serial number 11, if your lordships have 703. And then 2014, and then the current. And over the page, my lord, is the approval letter. At the top of the page says approval of fixation of pay for protection of pay in respect of in-service teachers. So we are called in-service teachers, my lord. And that protection of pay happened on 16/12/19 at the foot of page 704. And the service book of this first petitioner is at 705. So, but I am, Millard, so therefore I have started by saying we are a sui generis category, Millard. Because we are not somebody who has in-service candidates were allowed to give, Millard, and if a lordship were to just permit me to show page 389, which was a public notice issued by the West Bengal School Service Commission, allowing us to participate. And of course, I must point out, Lord, that we had to go to the High Court for allowing us to participate, because the scheme for the centralized recruitment happened for the first time in 2016. So we went to the High Court. That High Court order is also on record, saying that yes, we should be allowed to participate. And then, Lord, the public notice came, which is at page 389, which extended the period for filing filing our application up to 7th October 2016.
All right, we'll consider this, yes.
So therefore, my lord, I am respectfully submitting, my lord, that it should not be the same brush, my lord.
Yes.
And now we are all over age. So even if, my lord, fresh selection were to take place, we as in service can't even apply. And one is to retire next year, as I pointed out, my lord.
Yes.
I'm very grateful. Much obliged.
Yes, Ms. Diwan.
Lord, may I be excused, my lord?
Yes, yes, ma'am.
Can I follow that order? Because I would be also representing those persons against whom.
You're Mr. Pratik there? All right.
But I prepared a short note. Well, my endeavor, since I have also lost the job because of this judgment, my endeavor before your lordship shall be to show the gross incorrectness in the judgment itself.
Yes.
But first, lordship may kindly see the very basis of this judgment, which is challenged before your lordship, was the November's order passed by this honorable court. In the order, my lord, there are 7 fundamental directions which were required to be gone into and followed by the honorable division bench. Lordship, kindly take the first. I have just jotted down that. Now, the first point was, Lordship may kindly put a difference between two situations. Usually, my lord, whenever the matter is heard by your lordships, lordship send the matter, then there is an expectation that the matter will be decided on merit. But there are only few cases when your lordships feel that not only the merit is to be decided, no matter it was pending for last 3 years, 4 years, etc., but also the point of maintainability is to be decided, then, my lord, my respectful submission would be that there should not be any prejudice as long as this order stands. So the first part of the order was though there has been detailed documents, all points, this Honorable Court felt for whatever reason that there is a necessity to first decide the maintainability of the writ petition itself. The second was to examine the admissibility of the OMR sheet images. Third was in November 23, when all the documents, affidavits by the CBI and School Service Commissions, everyone was before your lordships, there was an observation in paragraph 8. At this stage, no such outstanding case, because Justice Gangopadhyay passed an order for termination of the large number of teachers. So this was the observation by your lordships. Fourth was, these allegations would have to be established through evidence. Well, I would correlate on this score how the Honorable Division Bench have completely gone incorrectly. Fifth was, well, this is important, to ignore the findings of the earlier Division Bench on Rule 17 plus to decide afresh. Lordship may kindly connect this with the point of maintainability, because the situation at that point of time, my lord, before this Honorable Court was that the Honorable Justice Gangopadhyay directed the School Service Commission that you must invoke your power under Rule 17. My lord, School Service Commission is a recommending authority which is governed under a particular rule, for the time being 2016 rule. Once someone is appointed on the basis of a recommendation, as an employee, I am governed under 2018 rules, which is a separate rules altogether. A point was taken before the High Court, before the Honorable Justice Gangopadhyay, and also before the then Division Bench, that once the recommending authority recommends and thereafter an appointment is done, the recommending authority becomes functus officio. But there was a direction by the Justice Gangopadhyay to the recommending authority that you invoke Rule 19, Rule 17, by which you terminate all the ballot, whoever at that point of time the court found that their appointments were illegal, invoking Rule 17. So that point, whether that would be done or not, that was required to be decided, that your lordships held. Now last one, and the next page, CBI to complete investigation and submit its report. Well, this is very important. Lordship may kindly see that after this order, this was a November 23 order. After this order, well, what is usual and what is expected is that the CBI will file a report before the Honorable High Court saying everything, whatever they have got to say. Now, there are 3 reports which were filed by the CBI. First report was of dated 9th of January 24. That does not contain anything of 65P, anything of scan take, anything of whatever is found to be fundamental today before your lordships. Nothing. Absolute absence. Thereafter, after 19 days, second report was filed by the CBI, 16th of January 24. Lordship may be surprised to take note, in the entire report, there is not even a single word on scan take. I have seen that on the very first day when this matter was moved, one of the basic points that was expressed by your lordship, that how there can be somebody who was not even getting the tender, that's a scan take. So that's an important issue. So after 19 days in the report for the first time, my lord, first 9th of January, nothing. Not even the 65B certificate. Despite November order, there is a requirement to prove it admissibility. 16th of January, no whisper, no word, no sentence, no document on scan take. Last report, 5th of February 24. Now, Lordship may kindly look at 2 fundamental, according to my understanding, flaw. My lord, after the amendment of the Evidence Act of Section 59, if a particular record happens to be electronic record, the only way of that electronic record to become an evidence is 65B and 65B alone, as held by your lordships in Anwar judgment. Now, there are two sets of electronic records, as per the last report of the CBI. One Scantech, one Pankaj Bansal. Lordship may kindly have a look at, my lord, I am referring to the state SLP for the convenience, page 768. Lordship has got. Lordship may kindly have a look at this. This is signed by authorized signatory Sri Pankaj Bansal, data analyst, Messrs. ND Infosystems Private Limited. But I could have understood. My Lord, if I can give an
So
example.
what's the drift of your argument? We're not
May I
able to
just,
get-
may I just say, and then.
Yes.
I was just thinking of a situation, my Lord, as a counsel, now if I sign here, I am signing in the capacity of, my Lord, as a counsel, as an advocate. When I go to my son's school, when I sign there, that signature is not, my Lord, in the capacity of a counsel, as a parent I am signing. I do not say that Pankaj Bansal could not have signed in the capacity of an ex-employee of NISA. I don't say so. I say that this is having not done so. Can you have a look at, my Lord, who has signed it? Signed, I read it out. Authorized signatory, Sri Pankaj Bansal, data analyst, Messrs. ND Info System Private Limited. Well, this document is absolutely nothing.
There is an absence of data. That's the whole point.
That would come. It's not correct. That's not correct. First, what I submit before your lordship is this. In November 23, this Honorable Court wanted the High Court that look at the 7 points, decide the writ petition, including the point of maintainability. If you have to issue any order on the OMR, first decide the admissibility of this OMR sheets as, my lord, seized by the CDI. Now, what I, my lord, submit before your lordship is this. Your lordships have categorically held that it is 65B certificate and certificate alone. Well, I shall be showing that specific paragraph, not the affidavit, must disclose what is required in the 65B. Now that will come only after someone, my lord, who is relevant with the organization, he is, my lord, giving a certificate. Today, I could have understood a certificate is given by the Scantech. I would have understood a certificate is given by any employee of the NISA. But this certificate is by X, Y. So this has got absolute a zero value as far as the evidence part is concerned. Now, lordship may kindly take, my lord, the last but one page of my note. Lordship may kindly take, my lord, the ANVA judgment, my lord, in the compilations I have given.
We'll see that later. We'll see that judgment later.
My lord, that paragraph 14, if I can read it out, my lord, the relevant portion. Any documentary evidence by way of an electronic record under the Evidence Act in view of section 59 and 65A can be proved only in accordance with the procedure prescribed under 65B. So that's the only way out. Now thereafter, I'm skipping few portions. 14, last 2 lines, which is called as a computer depends on the satisfactions of the 4 conditions under 65B2. Now, lordship, kindly take last part 1 page of myself. What, if I can use the word, the blunder the CBI has done? My lord, they have stated in the certificate, I have the exclusive possession of custody of the records. What is required under 65B2A is a lawful control, not the exclusive custody. There is no word, because I can take on the face value that, yes, he is saying I am in the lawful control, that is fine. But there has to be words like lawful control, that's a requirement of 65B2A. Instead of the word lawful control, the word that's there, having exclusive custody. Well, this is the first. Second, there has to be a specific statement in the certificate, my lord, that it is regularly fed plus ordinary course of activity, that is 65B to B, completely absent. My lord, third requirement was computer was operating properly, 65B to C, absent. Last was information equals to reproduction of what was fed in computer in ordinary course of activity, 65B to D. So therefore, the four requirements under 65B absent in the certificate given by Pankaj, who is not even of NISA, one. Other thing is the scan tech, which in the last report of the CBI has said that he has also done better scanning. There is not even any valid certificate by the scan tech. Now, in this context, now Lordship may kindly come paragraph 335, for which we have lost our job. 330. That's the 17 reasons. Well, I just forgot to indicate one more reason. In the last report regarding the data of the Scantech, Lordship may take note of the fact that what the CBI said in their report, that they see some data in the form of .dat. Well, in the protocol for any malware scanning, the data has to be in the JPEG or the TTF file. That's the protocol. But it can always be converted to .dat, but that requires another software. The reason for this submission is that technological aspects, a little tweak can make a huge impact. That's the requirement of 65B very stringently. So,
All right, we'll hear them on the 65B.
Yes.
Let's hear
my lord,
them. Anything else?
Yes, my lord. 335, my lord, the first reason that we lost our job, that SSC has appointed the agency, namely NISA, for the purpose of scanning and evaluating OMRs by a closed door. My lordship may kindly consider this. For last 7 years we are serving. I don't have really information, but my instruction is that many competitive examinations, because of the reason that the candidates do not get to know who would be doing the AMR, it is done in the closed door. But I don't have the data. That's the instructions I have got from my clients. Now, High Court could have at least made an attempt to see, is it an unique thing which is done by the School Service Commission in West Bengal, or in all other competitive examinations, the closed door is the common phenomena, because so that the candidates do not get to know this. The second one was why the data Scantech was there. Lordship must. My lord,
Mr. Siddharth, now let's hear some other people also.
just 2 minutes.
Yes.
My lord, the rule 2016 rule, Lordship may kindly have a look, rule 21. Well, I don't say that it's a very proper rule. It should have been better. But the rule requires that this has to be destroyed.
But the scanned mirror images have to be preserved.
That is not in the rule. That's not in the rule. That's, my lord, the common sense, I can say. I can say, yes, it's a good thing, it's a transparent. But to say that the rule requires that mirror image should have been there, but that's the findings of the division. That is incorrect. Lordship may kindly have a look at the rule.
There's no requirement of
No,
maintaining a mirror
no
image.
requirement. No requirement. And my lord,
The RTI Act. Rules cannot really supersede the parliamentary step of RTI.
well, may I hand over the, my lord, this 16 rule? And Lordship will not find a single sentence. 24,000 persons have lost their job. But among 149, my lord, as I am representing, there is one wish. But I do say, as a responsible counsel, I do say, my lord, this rule is not proper. That Lordships always come across. It is definitely not proper. But at the same time, as long as the rule is there.
But is it, according to you, is it possible to segregate those who are tainted from those who are not tainted?
Well, there are two ways of looking at it. One, Lordship is assuming that some people are tainted because.
According to you, nobody is tainted. According to you, nobody is tainted.
Well, I am representing that 19,000.
Where do you stand? I mean,
I say on a point of law, when this honorable court directed that you have to decide admissibility.
but according to you, is the entire process without taint, or there are people with taint?
No, there are, I would say, tainted persons. Who are those tainted? Who have been given appointment after expiry of the panel, number one.
Yes.
Anybody who was given appointment after expiry of the panel, of course, this is illegal, and that can easily be found out from the very date itself, and they should go.
Then,
My lord, if there is,
apart from this category,
my lord, if there is any candidate who even without participating has got the appointment, must go. It's illegal.
yes.
All I say, my lord, the parameters of illegality, Lordships, definitely apply. But if your Lordships apply the parameters of illegality after observing or finding that there is a sacrosanct electronic records, that is absolutely right. And therefore, what is the wrongs has to be found out after seeing what is the mismatch from this one. That is only permissible once that electronic records are found to be correct under 65B. But on the face of it, well, tomorrow somebody else gives a certificate. This would be, my lord, allowing an amendment to the 65B itself. And to that effect, my lord, the only submissions by the counsel of the CBI was one paragraph in his entire judgment, paragraph 29. We have submitted our charge sheet, matter is pending. That's all. There was no answer to my very fundamental point that this is so important. Scan take, NISA, why didn't you say so at the first time? Why didn't you say so in the second time? And why you are saying at the last time? But I have a probable answer. They knew that 65B certificate signed by someone, some MD electronics, that is legally, that has got no value, zero value. That's the reason in November 23, they did not show it before this honorable court. That's the reason in the first report, they did not annex it. Only in the second report, they annexed it. And in the last report, my lord, a new story of the scan take came, which I said that there they are referring to .dat format, which is a processed. But today, I am also representing visually challenged candidates. about 100, though only one person has signed and is before your lordship, they have also lost a job because of this judgment. My lord, my respectful submission before your lordship would be that the criminal case is pending. Ultimately, it would be decided who has done what and he must be punished. Prior to that, in a writ proceedings, whoever has jumped the panel, they should also go. But other than basing that this is the CBI record so sacrosanct may not be a proper interpretations of.
Thank you.
These are my respects.
Yes, Mr. Who's now going to argue? Maybe the next counsel under the, Mr. Rohitgi is here.
I am there in.
All right, now we have Mr. Madiyal, right? With
I
Mr.
just take
Rohitgi.
3-4 minutes. I'll not take more than that. Much of what I.
1 second, we'll go. No, we'll go by the rules. So we'll go by what we have got the record now. No interventions. Yes.
Because I appear in item 17.2, 10.5, 17 and 18.
All right, what do you have to say?
Yes, my lords. My submission is that segregation was possible and it ought to have been done. The petitioners in these matters, my lords, are all persons who are completely untainted, even if the OMR is to be taken as correct. The mirror image of the OMR is taken to be correct. In fact, if my lords have para 240 of the impugned judgment, the SSC 240, that is para 240, PDF perhaps 243 minutes. 249. There is already a segregation that was placed before the Honorable High Court.
249.
Yes, para 240, my lords.
The page?
Page 200, PDF page is I think 249 of the state's SLP. There's a tabular column at the bottom of it.
Para 249.
No, para 240, PDF page 252, I'm told. PDF 252. 243. 252 of the state SLP. Yes, so there is a segregation, and my lords may just note at the right-hand corner of that table, the discrepancy found even, for example, in 9th and 10th level is just 8.5%. The CBI finds, my lords, discrepancies after examining the OMR sheets, the mirror image, in respect of about 953 candidates, in respect of most of whom there was, my lords, a withdrawal order issued, which was stayed by your lordships over here. But my only point is that segregation was possible and segregation was done. And therefore, my lords, today in the 9th and 10th level students, there were 11,610 candidates who were selected. Out of that, my lords, as per this table, I am going by this table.
Yes.
As per that, even according to the SSC in this, the alleged irregularity was only 993. Therefore, my lords, if segregation was possible, as the SSC has told your lordships today, it is possible. The CBI has identified those individuals. The SSC before the High Court has placed data identifying those individuals. There would be no reason, my lords, to paint all of these candidates with the same brush. And to remove them. And this would especially be so, my lords, because 2018 these individuals have been appointed and are continuing to work.
All right. Thank
Grateful.
you. Mr. Diwan?
Well, it's just one suggestion, one aspect. My lords, your lordships may also consider if segregation, if today the data which the CBI has is to be examined even by an independent committee to see if that segregation is valid or not. Grateful.
I have two sets of submissions to make. The first is in the petition, which is at serial number 19.3. It's titled Chinmoy Mundal. Now, may I just make my point here? There are three petitioners here, three SLP petitioners before your lordship in this particular petition. None of them were parties before the High Court. And we've therefore come here with leave to appeal this particular judgment. Now, I come in what can be broadly described as that untainted category, and this is very important. So 2 points I'll make straight away. First, I'm in the class 9 and class 10 band of assistant teachers. Second, I am not, in a manner of speaking, tainted either by the OMR issue or by the rank jumping issue. Nevertheless, the impugned judgment in para 363, Roman 2 says, all appointments granted in the selection process involved being violative of Articles 14 and 16 of the Constitution are declared null and void and cancelled. So one more fact I want to mention. At page G of my list of dates, I have given you the dates, so I'm not going into those specifics. I was appointed in 2018 and 2019. There are 3 petitioners. So between 2018 and 2019. I've been in harness for more than 5 years. Apart from being in harness for more than 5 years, Manoj, we've taught over there as assistant teachers in class 9 and 10. There's absolutely nothing against me. There's no finding. I'm not on any list of any CBI or anybody at all. Now, in this backdrop, let us go back to this paragraph 240 for a moment and just study it a little carefully. The 3 bands in para 240, which I understand is at PDF 252.
Yes.
Now, let's see these numbers. I'm on the first band of assistant teachers. 11,610. Now, I ask, the question I pose to myself is, could this have been done through an executive order? I believe if it were done through an executive order, this type of cancellation, that everything is going out, your lordship should have struck it down as treating unequals equally, which is completely wrong and has been frowned upon. Now, out of 11,610, the OMR issue, assuming there is an OMR issue, is only for 808. Now, look at the second column, rank jumping. I am not, as I mentioned, I am not on the
OMR issue is that the OMRs were not available.
There were some blanks, there were some available. But this is only what now, this is post, whatever the value of that investigation by the CBI.
On what basis did the SSC submit this statistical report? Now we are taking this report.
Because there were lists which were filed by CBI, for example, which were there. That list is also appended in annexures to this document.
Are those OMR sheets recovered from the residence of that Mr. Pankaj? That is the start and the end of the CBI's investigation. The CBI says that in some of those OMR sheets, some people who have got 0 have been selected. Now that's the whole case against. So if that record which is recovered from the residence of that gentleman and that certificate has been attached.
How many OMR sheets have been recovered from Bansa's residence?
Mirror images.
Number is, there is no number given. There is no number given anywhere. If your lordship will read the last of the CBI, the scanning was done, the board was to scan. Board of A to scan. Agency A gave it to agency B. This Pankaj is the employee of that agency. Then some employees of that agency split and make their own private agency. And then Pankaj goes and joins those employees. And he has given a certificate as an employee of that split agency on the basis of record which is recovered from his house. And 25,000 people are losing their job. That is the whole open and shut case finished. The judge has addressed no other argument which was raised before him. And how did we lose our job? The single judge who was hearing the case, in one order says, this is a case where the board should exercise power under 17. 17 is a power with the board to withdraw recommendation. The board says, yes, we will look into it. We immediately file an appeal before the division bench. And we tell the division bench that we have been working for 4 years. Single bench in a 1-page order says, board to look into it and exercise power under 17. Division bench says, yes, you have no right to be heard. Finding number 1. Finding number 2, 17 will apply. The same day when the division bench passes the judgment, The same day the board passes an order withdrawing our recommendation. And the next day our services are terminated. We come before this court here. Your lordship stays the termination. Your lordship stays the termination and says they should have been heard. And your lordship says, please go into the issue whether Rule 17 at all applies after a person is appointed and has served for 4 years. Now, all those arguments are raised, not a single word on Rule 17. The petition challenging the vires of Rule 17 is separated, segregated, and not decided. And the whole judgment is based on this 65B certificate.
Mr. Patwalia, Bansal signed the certificate in what capacity?
My lord, as an ex-employee, just kindly see one paragraph of, just one minute. Just kindly see one paragraph in the judgment, para 305. The whole cat will be, just see para 305 to answer this question of my lords. Who was authorized, who did it, and who gave the certificate? This is a matter, Lord.
Para 15. Yeah. Certificate is at certificate is at
Para 305.
Yes, just kindly see, Shyam, can I just,
Yes,
just show. Just kindly see para 305 of this is the last report. CBI has filed several reports in these proceedings. In its report dated February 5, 2024, filed in compliance with the court order dated January 24, it has stated as follows. During investigation, it was revealed that the West Bengal School Service Commission, hereinafter referred to as the Commission, had awarded work order to Messrs. Nyasa Communication Private Limited, referred to as Messrs. Nyasa, for scanning and evaluating the OMR sheets pertaining to the selection of Group D, Group C, so and so. Investigation has established that Puneet Kumar was the then director and Niladri Das was the then vice president of Nyasa Communication during relevant period. It has been established during investigation that Shri Niladri Das was in charge of operations in respect of recruitment examination conducted by the West Bengal Service Selection Board, frequently visited the office to attend the actual operational part, did the requisite liaison on behalf of the agency for necessary compliance of instructions. Shri Puneet Kumar, being the director, mainly looked after financial affairs. Now what happened? Investigation has established that scanning of OMR sheets was undertaken by NYASA at the West Bengal Secondary Board Office at Acharya Sadan under direct supervision of Niladri Das in the presence of WBSCC officials. It has been further established that NYASA Private Limited had further given work order regarding scanning of sheets to Data Scan Tech Solutions Noida, who remained present at the premises for scanning. After completion of the scanning, the processed data in the form of scanned images of OMR, scanned data were handed over by Data Scan Tech to NYASA, who took the same to their officer located at Noida in digital form, leaving the hard copies in the office of the board. Board handed over their answer keys in respect of all subjects to NYASA. Now, none of these agencies is giving the certificate. I'll show who's giving the certificate. Your Lordship may now leave a few paragraphs and come to para 9. Because next paras they explain the files. Come to para 9. During investigation, the service database of the Commission was seized by the Central Bureau of Investigation, containing all data pertaining to selection test of group B, C, D, so and so. During investigation, 3 hard disks were recovered from the residence of Pankaj Bansal, an ex-employee of NYASA located at Ghaziabad. Who is this person, or how can this record be relied upon? It has gone changed 4 hands. Now it is in, they have picked it up from the residence. During investigation, these data files scanned, these 3 hard disks were recovered from the residence of Pankaj Bansal, an ex-employee at Ghaziabad. The certificate dated 16/9 of 65B from Pankaj Bansal was obtained. He has not certified on behalf of any of these 3 agencies. Now they'll explain who he has certified. Was explained in triplicate with regard to genuineness of the data concerned.
No, but what they say is the hash values of these data files of Scantech solutions
Correct.
were matched with the hash value of the corresponding files recovered from the hard disk seized from Pankaj Bansal and was found to be matching.
Correct. So Pankaj Bansal would probably get it, but I am nobody to say so. In the criminal trial, this matter is pending investigation. Today you take this as the gospel truth and throw out 25,000 people. Now, how this company is formed? Now, if your Lordship will see, your Lordship has just read para 11. Now, if your Lordship just kindly come to para 15, just come to 15. What has happened? That original company split, just let me read para 15. That it is emerged from the investigation that before leaving NASA, Niladri Das and his staff
were identified in CBI.
just let me read, sorry, para 14 onwards. It'll come, it is coming, yes.
Of the CBI seems to indicate that the candidates in respect of whom there was a mismatch of the data have been identified.
Correct.
This mismatch establishes that the manipulation of marks of the written examination, the case of many candidates was resorted to and such candidates were identified. The comparison of these actual genuine OMR marks with the OMR marks available in the server shows that there is manipulation in 952 numbers of candidates for 910, 907 for 1112, 3481 for Group C candidates and 2823 for Group D candidates.
Apart from the fact that this segregation is possible, I am on a more fundamental point. My fundamental point is, how is this mismatch coming at all? The mismatch is because it is mismatching from what is recovered from Pankaj in his residence. Now, please read with me para 15. It's very important. 14 and 15 is very important. What happens to this data and where all has it gone? Just see now para 14. Para 14 and 15.
All right, read 13 also.
Yes, 13, no problem. That during investigation, several emails were found to have been exchanged between the accused officials of the commission, certain private persons and officials of NASA. These emails contain lists of candidates whose OMR marks were found to be increased in the server of the commission. Besides, these emails have been exchanged between staff of NASA containing manipulated data of candidate. This shows complicity. This is all somebody's Dixit, Lord. But now let's see, read 14 and 15. During investigation, it emerged that in the year 2019, Shri Niladri Das of NASA Communication left NASA, started his own business in the name and style of Messrs. ND Info Systems. Now, this is the certificate coming. Now let's read further, Manoj.
CBI second deputy agent.
I'm trying to call upon the other side. If anybody wants to argue for a minute so that you don't have the...
Just one more paragraph. One more paragraph.
This is very serious.
Minutes to argue, Manoj. I need that.
Yes, yeah.
I'm going to argue more fundamental.
This is completely wrong.
How about Justice Gangopadhyay?
How are these people losing their
And I'm
jobs?
going to
Their
show
vested
you
rights?
what a grave miscarriage of justice has taken place. It was he who ordered CBI inquiry. Pending that hearing, he gives a public interview and speaks loudly about this matter and says, I'm going to send everybody home. But this is shocking what has happened. Your Lordship will have to take cognizance of it. We cannot allow this kind of judicial misconduct to go unpunished. He gave an interview, and I will read interview, my Lord, in which says, yes, I have political aspirations. And someday if somebody invites me, I will accept it. But this is really, and when he took cognizance, there was no prayer for CBI.
Mr. Dave, before we go into these broader issues, can we just focus on what the nitty-gritty of the matter?
Yeah, we'll go into the nitty-gritty.
We are 6 years, we have worked. Your Lordships are right. Please then grant a complete stay to us. Even these 956 people, what happened? This magical dish was sent to Forensic Science Laboratory, Hyderabad, by CBI. They said we cannot even verify it. They said we cannot verify. Now, as Mr. Patwalia rightly says, this is subject matter of criminal investigation. But pending that investigation, should we be damned? I can understand after a judgment. But in cross-examination, this Bansal will collapse in a minute. So, my Lord, we are being damned on this so-called, and my Lord, one thing, when your Lordships remanded the matter, your Lordship
Who's
said...
appearing? Can we just for a moment have... 1 second. Do you want to hear for again, Mr. Jaideep Gupta here? We just want to...
There is only one thing, Your Lordship.
Just call Jaideep.
Lord, when you are just a second, when your Lordships remanded... Abhishek, just a minute. Abhishek. When your Lordships remanded the matter, your Lordships expressly record, there is no evidence available on record as on today. Therefore, if there is any evidence, it may be put. Only evidence is this magical CD, which is completely inadmissible under section 65B2. It is not, the certificate is completely dehors 65B2 read with 65B4. Completely, read the certificate, my Lord. And your Lordship's judgment in 2014, which has said how this evidence can be taken. So, my Lord, we are being condemned after 6 years, my Lord. We have families. Nobody complained when Justice Gangopadhyay took the matter. There was not even an allegation of impropriety in that petition. I will show that petition. So, my Lord, it's something which is really a grave injustice.
I wanted to only intervene to alert one thing, Willis.
suggest one thing. If you had a little bit of faith in the court, please sit down for 5 minutes.
All
Let's talk to the other side.
All right, all right.
We'll talk to the other side, hear them, and let's put our
Certainly,
doubts to them.
certainly, with one caveat for 1
If
minute.
if after hearing them,
No, no,
Dr. Singhvi, if after hearing them we are inclined to dismiss your petition, we will give you a full hearing.
I'm very grateful. I'm saying
That's the
something very.
least which you will expect from
No,
judges
well,
who are
the
trained with
question
the-
of not trusting
in
the
the-
court.
Great.
Well,
The technical
I want 15 seconds to point out something your lordship doesn't know.
Give us-
I am awaiting my turn because I am going to ask your lordships to unhear whatever you heard. I am a category who is nowhere in the CBI list, nowhere in the.
Singhvi, that's why we'll,
Unrelated.
if we are
I'm the
inclined,
so-called-
if we are inclined to come to the conclusion.
You haven't, lordship, haven't heard our
If we
category.
are inclined to prima facie come to the conclusion that your petitions are to be dismissed, then obviously we can't throw your petitions out without hearing each one of you.
We are not started now.
Right, we just want to, we are conscious of the fact.
We'll wait our turn only on this understanding.
Therefore, your clients also should not get the impression that we didn't hear you and then we are dismissing your petition.
All right.
We have some doubts, let's put them to the other side.
Certainly, but ORS, please keep in mind.
Jaideep, where is
Some of us
Jaideep?
are like this, you have not.
1 second now, please. Jaideep, is it possible, I mean, do we have any cogent material today to segregate the tainted from the untainted candidates?
That's right.
Now, you know that para 240, come forward. Para 240 of the judgment, is a chart. Now, on what basis did you prepare the chart?
The digital data which they had obtained from that particular employee. And Milord, on that basis, it was prepared.
And we are out of that. That's the point.
And Milord, I may tell you one more thing, Milord. Based on that same CBI data, Milord, we have issued letters of revocation of appointment for some people. In fact, Milord, 2 of the issues raised but not decided because of the nature of the directions later on. 2 of the issues raised was whether we had the power to revoke under Milord section 17, rule 17, and whether we in fact correctly revoked or not. These 2 issues were raised. So Milord, partly Milord, we have already done the job of segregation. Milord, we had already removed some people. We had
All the 5 lists by them for 5
Milord,
years, we are nowhere.
I am Milord, only Milord saying that if your lordship permits the data to be looked into, Milord, we will be in a position to segregate. If, however, if your lordships feel that that data is not acceptable or, Milord, it doesn't have the necessary weight, Milord, then there will be a bigger difficulty.
Or a learned retired judge can segregate the chaff from the wheat.
No. First of all,
Highly. That's a different argument.
I'm sorry, Milord. First of all, we
That's
have
a
to
different
do it.
argument.
We have to do it. It is not something which can be done.
All right, who's appearing for the other side?
I am concerned about my category, I'm out
All right,
altogether.
who's appearing
That's
for
all.
the other side?
This is the job which was sold in the market.
Some petitioners will not get it.
At all, that's going to be our point. So
That-
therefore, cannot throw us to the wind on the basis of a change which is non-existent. We need to show that to your lordships. This change is a creation, my lords, of one Mr. Pankaj Bansal, who is completely, my lords, incredible. His agenda was different, ex-employee joining a competitor, and based on that, my lords, you create a taint. There's nothing to compare it to. There's nothing to compare it to. There's absolutely no evidence. And therefore, on that basis, a segregation is created because the commission wants to save some. That cannot be. They have to save all. There is no evidence.
Lord, your lordships are dealing with,
All.
your lordships are dealing with category B employees appointed or recommended beyond the expiry of the.
All right, let's hear the other side.
Lord,
Yes.
on this, my lord,
Now,
can I
we
just
have
take a
to-
minute? Can I just take a minute?
We have, come along. Let's at least hear the
All
other
right,
side.
very well.
Very well, very well.
Yes.
This is a job scam. Jobs were sold in the market at the price of 10 to 15 lakhs. And when Milord,
Now, how many people stand to be affected by this order cancelling what's the total universe
the
now?
total Milord cancel should be Milord 22,930, 25,000.
25,000.
Now Milord,
Do we
none
have
of them,
precise figures?
yes,
If you go to the synopsis at page B, we are considering 3 categories. Assistant teachers 9-10, assistant teachers 11-12, non-teaching staff Group C, non-teaching staff Group D.
Four categories.
Now, 4 categories.
Total.
Now, do we have a bifurcation among these 22,000 candidates? How many fall into each of these categories?
I just give you also the detailed data.
Yes.
Milord, the. Joshua,
Some idea.
But in group D,
This chart is in total by 240 has all the recommendations.
Give us copy.
Extra copy.
Give us copy.
recommendation was made 23,123.
This is yours, what you have given us?
Yes. Lord, this is on the basis of the data supplied by the school service commission, CBI.
Just please hand across a couple of copies.
And the illegal appointments total admitted till date was 8,000.
Now, 1 second, just go step by step, just 1 second. Give a copy, one copy to the other side.
Get.
All right, one, illegal appointments. Now, OMR issue, I mean, this OMR issue is a very vague statement. OMR issue is that how do you formulate the OMR issue?
That the WEMA sheets which were recovered by the CBI was given to the School Service Commission. They have accepted that. School Service Commission being the custodian of the WEMAs, they did not dispute the validity of the CBI retrieval, number one. Number two.
CBI retrieved these OMR sheets from where?
From the employee of NISA. NISA no more existed today. There are many situations which come for consideration. NISA had the Pankaj Bansal and Niladri. Now they have formed a new company. The CBI will raid it. They got it retrieved from Pankaj Bansal, who was the employee of NISA. And NISA no more exists today. That's very important. Now, when this retrieve disk were supplied to the SSC, SSC says that we accept this. We do not dispute the validity of it. The furthermore important, during the hearing of the matter, the Honorable Court gave everybody opportunity to see the WEMA retrieved by the CBI. None has disputed that.
No, that is incorrect.
None of the candidate has disputed that. That's a fact recorded.
Our matter cannot be heard.
Now the OMR sheets contained a manipulation, or what was the problem?
The WEMA sheets did not contain manipulation. WEMA sheets were filed without any marking, zero WEMA sheet. They have been shown to have secured more marks in the website of the SSC. That is the mismatch.
There is a discrepancy.
They have filed blank WEMA.
In certain cases, there is a discrepancy between the digital OMR data and what is the final record maintained by the SSC.
Yes. Therefore, the WEMA is the foundation which shows that there was a huge manipulation.
The number of mismatches are all started.
This is a great scam. That's why we say. And this.
According to you, in your chart that you have given us, the total number of recommendations which were made were 23,123.
My lord.
According to you, taking your case at its highest, the total number of illegal appointments admitted until date are 8,324.
Which could be found as of date, because the SSC files an affidavit before the court saying that we could not yet reach to the final calculation. That's the affidavit SSC work.
Right. But therefore, at the outset, I mean, the instinctive reaction is that if 8,324 appointments, according to you, are illegal, what is the ground for setting aside all 23 appointments?
No, my grounds are that entire selection process is tainted. Entire selection process.
How do you say that?
Starting from the appointment of NISA, the manner which was appointed, I will show the NISA people.
So assuming for a moment that NISA thing again from the share.
Yes, can
Now-
be done. I don't mind.
Right? So, then what is the justification for us today to uphold a direction for throwing out all 23,000 people en masse, unless we come to the conclusion, that the process is so tainted by fraud that the entirety of the selection has to go.
But that would be my submission if not allows me to.
Now, point number 2, which we wanted to identify.
As of today,
One second. Mr. Gupta, do we have, is there today an identification of those persons
Yes.
whose appointments are one, illegal, in the sense of the OMR issue, rank jumping, beyond the number of recommendations after the expiry of the panel?
Absolutely.
Are
This
we-
is entirely on the,
Names and-
entirely on the
names and
basis of
numbers.
hard disks. The entire thing is on the basis of free hard disks which come from a source
Milord, we have
which
even
is
prepared a
completely
compilation.
hard disks are accepted by.
How can that be a basis? Because ultimately it leads to criminal consequences.
No, but therefore-
65B is a very serious.
Look, if we have to, I'll tell you one thing. If we are inclined to take this, to reserve this matter for a fuller consideration.
Gotcha.
At the same time, we can't obviously, now it's obvious that some appointments are tainted,
Gotcha.
right? We are not inclined, we may not be inclined, subject to hearing everybody, we may not be inclined to issue an unconditional order of stay in respect of all appointments.
Very well.
So those appointments which fall into certain clearly defined accepted categories, there can't be a stay in respect of those categories.
Very well.
Right? Now, which are those 4 categories which we'll have to exclude?
No, just one thing, look,
But
working
I-
since 2018 and petitions filed
Yeah.
3 years later, 4 years.
Para
271 of the judge. 271 of the judge.
Milord, let me just summarize the position, Milord.
Just one second.
242, first 2 lines of paragraph 242.
Can you just give us the PDF page, please?
Milord, just, may I summarize?
Para two of
I'm
the
not
judge.
having anybody.
271.
Mr. Maninder, you are living in a bullock cart age.
Yeah, I asked my friend Malad, I didn't.
What, your friend, you should have an iPad now.
Follow me, yeah.
Milord, may I summarize?
Para
Milord?
242,
Without-
if your lordships have it, Malad, first 2 lines. First 2 lines in para 242.
Otherwise, Maninder, go and take some training in the Delhi High Court. You'll get some good training online. This is not acceptable.
We will, Malad. 242, first
Yes.
2 lines. Para 242.
Mr. Dave, are you also in the same category or?
Malad, 242.
Just give me the PDF page. Anybody who has the PDF page, please tell us.
200
All right, just look at those. Para.
242 of the
42.
judgment.
You want to read
It should be
242?
PDF 242. I'll come to 242, I'll read 273, then come to 265, just permit us.
Yes,
please.
yes.
242, if your lordships have got it, Malad.
Yes.
In course of hearing, SCC did not discount the fact that possibilities of further illegalities exist. Now, before I go to 265, come to 273 straight away. 273. Because there are 3 authorities, all 3 have raised hand and candid that we cannot give you the total number. Please see 273. Yeah, 1 minute, bhaiya. SSC had 273. PDF said 260. 273.
Yes.
SSC had no stage of hearing claimed that it was able to check all the records and be definite as to the number of illegalities in the recommendation made, but had limited itself to those figures as stated in the paragraphs above. In fact, reports in the form of affidavit filed by SCC from time to time had always stated that they discovered the illegalities as were brought to their notice by the litigants or an order of the court. This is number 2. Kindly now come to 265.
Before that, if not, you can take.
Now, just one, 265, para 265. 257 is the PDF page number. State government therefore has accepted there were widespread illegalities in the selection process. Now, these are admitted facts, nobody has disputed it. And that the number of persons who received appointment illegally
could not be determined with exactitude. So this is the foundation, my lord, in your lordship judgment that the entire thing has to go. They had resolved to create supernumerary posts to accommodate the illegal appointees. In other words, state has resolved to expend taxpayers' money to accord sanction to an employment secured dishonestly. Such course of action of the state violates section 14. Other two paragraphs, my lord, say that the SSC says we have not made recommendation. Board says I have appointed on recommendation. Recommendation don't exist. And impossible to find out how many cases. And SSC admits candidly in its report, in every report, I have conducted this number and determined on the basis of the complaint received from the candidates and, my lord, the agency.
No.
I am reading only from the judgment. And there is no ground that, very well. Now, my lord, kindly see only 2-3 paragraphs more.
Para 33, that's why I
Kindly, my lord. Kindly come to 257, para 257, role of the state government. PDF page 253, para 257. And, my lord, your lordships were told no criminality has been found. A application for sanction for prosecution of the state officers is pending. When the High Court asked, by what time you will decide sanction, they said after the election. Kindly have a look, my lord, 257. The role of the state government in the writ petition and the appeals have been heard by us has to be taken into consideration. And your lordship may also keep one thing in mind. In addition to CBI, there was an SIT and the CBI to work with the SIT. SIT having sought sanction is in para 258. Complete evidence of illegality. And the argument on the other side which you were hearing, my lord, no illegality. Kindly see, my lord, as 257. No, kindly, I'm sorry, I'm so sorry.
Our question is very pertinent. Today we are trying to consider whether segregation is possible or not. Just come to internal page 240 of the judgment, which will be para 305
Yes,
of the judgment.
yeah, where this is CBI report is quoted.
And CBI report has been reproduced by undeserving candidates. That's your case. This mismatch establishes. Now, the entire thing originated from residents of Bansal when those OMR sheets were recovered. And that is the reason why you have obtained 65B certificate also from him. Data is recovered
That
from
is CBI.
He has to say something, correct?
No, that would be CBI. I appear for a candidate, not a writ petition.
Fine. Just make us understand, last 5 lines at 240. The comparison of
these actual genuine OMR marks.
So now there are 4, just 2 minutes. There are 4 categories. There is manipulation in 952 numbers of candidates of Roman 9-Roman 10. 907 numbers of candidates of Roman 11 dash Roman 12, 3481 numbers of grade C candidates, and 2823 numbers of grade D. Who are these candidates? Who are these candidates? What are the names of these candidates?
That the commission has to give it to your lordship.
No, we have the names.
No.
We have the name.
We have the names.
No, what I'm just.
That the names and the roll numbers of the candidates.
The more important question is not who is Pankaj Bansal? He never had custody of this. They've taken hard drives from an ex-employee who CBI itself says that he was not the person in custody, Niladri Rai was.
On the hash values, the hash value has to main
Thing here is. One sec. That in the same report, earlier paras of the same report shows that Niladri Rai was from NISA who was in charge of this. Pankaj Bansal was never there. And an ex-employee who is illegally holding on to some hard drives, those hard drives procured by him, they take a 65B certificate from him.
Then
The
all
accused person, an accused person who is never in custody.
If with regard, Lord, if with regard to every candidate, there are two OMR. One with the lower number and one with the increased number. That's the end of the matter, my Lord.
Only on the basis of an illegally procured hard drive.
The only thing is that can that be said about every one of those?
That's what I am respectfully submitting, my Lord. That the commission says, I have not examined the entire record, whatever examined, this is the result. Let them examine fully.
SSC come
Number
forward
one.
with a statement before they vote on affidavit who are genuinely done. We have no concern with that.
The number two, my Lord, the state is castigated here. Kindly have a look at the state, my Lord, what the High Court has found.
If the SSC says they're genuine, they're genuine.
If, my Lord, the OMR is, for every candidate, there are two OMR, the entire case be done afresh.
Yeah, just shut up. ওই যে affidavit বার করতে হলো, বার করতে পারবে না। হয়েছে, ওর last affidavit আমরা করতে পারছি না finally। যেটা আমি দেখি, যেটা রেকর্ড করেছে
Lordship, my lord,
One
only, if my learned friend, my lord, if your lordships can come to page 243,
Yes, my lord.
PDF. I don't have the papers, my lord, but I'm not given the papers.
Before that, my lord, the lordship is just keeping in mind, my lord, various cases have come up with regard to this kind of a illegality. And the illegality modus operandi which seems to common is, my lord, that the original OMR within the commission, blank OMRs, my lord, where the candidates' numbers are changed are always either in the chairman's house or somebody who's close to chairman's house. They are all caught for, or they collected from there. But the point which is, my lord, what deserves your lordship's consideration is that if, my lord, in the table at page PDF 243, if the illegality is from 10% to 45% in the OMR, with the admitted statement of the commission, state as well as the board, that the entire record has not been examined without examination of record, if the OMR inconsistency is between 10% to 45%, in 4 exam, my lord, it's a classic case of calling for a fresh election. And number 2, just 1 second now.
Pilot will. But
Who is the statement to make a decision on my behalf? Now that the OMR seats to be destroyed.
The FCI was.
They want bogus certificate for lordship. They want to argue.
1 second.
My lord, the argument of 4 years and 5 years has been raised. My lord, in the judgment of Honorable the Chief Justice, my lord, in that FCI case of 2017, that where, my lord, caste certificates were false. And, my lord, Constitution bench believed that given a benefit to a postgraduate medical student, which fell for your lordship consideration, that is, my lord, reported as 2017. My lord, I have given you this much of. My lord, your lordship
Just 1 second, just 1 second.
My lord, just 1 second. My learned friend will permit me to give the citation, my lord. 2017 8 SCC page 670, para 24, my lord. Your lordships have reaffirmed R. Vishwanath Pillai, where when your lordship came to the conclusion that the gentleman took appointment on a false certificate, 27 years he had worked. Your lordship set aside the judgment, and in this judgment, my lord, Vishwanath Pillai judgment has been confirmed. These are all those cases.
Actually,
may I?
Actually, on various. Not been considered by the court.
Entertain. Kindly comes to para
5 years to
judgment.
If your lordship may have, my lord, of 2017 8 SCC 670.
This is 65B. Lord, it is completely
only to ensure that no manipulation is done.
No, this case is a case of 120B. I don't know why they are stuck at 65B. The case has traveled to 120B.
What 120?
65B has a
Your
different
case
purpose.
is only on a piece of evidence which is inadmissible.
The 65B for a different purpose to ensure no manipulation produced. And you have looked into it, did not dispute.
The OMR is only from that.
This judgment will assist your lordship.
Para 34. Para 34, 24, my lord,
But
24.
CBI has no role to play here. I don't know why my friend wants us. We would like to be heard first.
I need, my lord, for. Yeah, my lord, just permit me, I am completing, my lord, 43 PDF 243, that table. That table, my lord, 4 stream, and the illegality found, even whatever is found, is from 10% to 45%, coupled and blended with the statement made before on oath, before the Honorable High Court by the board, by SCC and by state, that this is not the complete figure. Illegalities are more, which more and more records you detect, you will find more. Number one. Number two, my lord, the period of spent after illegal appointment, which is void, has never found favor with your lordship in any case. And this para 24, my lord, para 24 of your lordship judgment in FCI, which I have handed over. Just have a look at para 24. I just want to show one line. Just one line, my lord, 27 years. After 27 years, your lordship held in R. Vishwanath Pillai that the appointment was void. Therefore, the working for 4-5 years, 27 years will not make any difference. Number three, my lord, the sanction sought by the SIT. SIT, my lord, is appointed first. The sanction sought by the SIT against the state officer, the High Court asked them, what time you will decide this? They said after the election. And since another bench has already passed an order, we would not like to do it. So, my lord, to argument there is no criminality when simultaneously sanction is pending is no argument. Lastly, my lord, when the matter came up earlier, your lordship did not say investigation. Investigation is all the more necessary when the bodies concerned with the appointment and making recommendations are not taking any responsibility. Everybody says, I wake up when I receive the complaint. And therefore, I will do a limited inquiry. I will not give you the full record. So, 10% to 45% in 4 streams. If that is the extent, my lord, where they say further illegalities can be found, it is a fit case, my lord, where everything must go and there should be a proper appointment selection. That's my respectful submission, my lord.
Second, Minister.
I am done, my lord. I don't need more time.
The way we are dealing with the nitty-gritties of the matter.
Defensible.
My lord, there are.
Foundation was Justice Gangapal order.
1 second. You are
CBI inquiry.
Mr. Dave, we are not here, Mr. Dave, we are not here scrutinizing the conduct of Justice Gangapal. We are, throughout the morning, we've been addressed on the nitty-gritties of the issue by both the sides. So let's confine it to that today.
Lord, we have.
Lordships. What he said and what he did. Purely Pinochet principle.
1 second, let me talk some.
Goes, the CBI investigation, the CD goes.
In fact,
Not the CBI report. हाँ, आगे बढ़ के दे दो. दर्शक को. Give it to them.
Kindly appreciate that.
Money को count.
This is the.
Master साहब, what master?
All right, we 1 second. Just 1 second. Look, if we look, unless we have maintained some order, we'll never get.
Lord, we didn't even speak a word when they were arguing.
All right, what we'll do is we'll place this in July. We'll just issue notice and place this in July. That's correct. There'll be no stay of anything. Either we are staying.
Can I say one job? Can I say
we find that it's impossible to
give us 5 minutes each.
It's impossible to have an orderly hearing. Yes. We will just simply issue notice. This is in July.
Lord, we didn't open our mouth when they were arguing.
In the morning, we have had very ordered arguments. Now we find that there's only a slanging match going on.
Correct.
We'll simply issue notice, place it in July. No stay of the investigation, no stay of the judgment of the High Court. That's the only way we can.
Lord, kindly don't do that, Lord.
Otherwise,
give us 5 minutes for the petitioner. Lord, we did not open our mouth when they were arguing. And they were not. Please don't say this.
However, 1 second, please. However sensitive the matter is, however politically fraught the matter is, we must understand that we are lawyers here.
Correct.
If we want to be politicians, we can go to parliament, we can go to the state legislature.
We are not
In the court, we are lawyers.
We are.
We may be on either side of the ideological divide. We don't care as judges about your ideological issues. We are concerned with the legality of the issue.
That's the point.
Right? If so long as everybody just bears that in mind, just leveling allegations against High Court judges, that's not going to carry the penny any further, because we have to decide on the basis
Till that time your lordship called upon us, we didn't open our mouth. Lord, your lordship called upon us, follow this judgment, 3 judgments I am handing over, Lord, starting from Krishna Yadav. Krishna Yadav is the first.
Regulate, please regulate us.
Secondly,
Please regulate us for 2
Yeah.
minutes each. Please regulate us for 2
but
minutes each.
with this kind of unruly behavior, all that we can do is not a matter to be dismissed. We'll issue notice.
Correct.
We'll issue notice.
We are
and we'll
not-
list it after the.
We are not doing it.
open.
Lord, if I can complete in 2 minutes, please have a look at those judgment.
We will,
Please
we will.
call out
that-
names for 2 minutes
The
each.
reason why we said yesterday that we will have an order for council to appear.
Yes.
Is that one council will argue at a time.
Yes.
We told you that if we are inclined to dismiss the petitions, we
Yes.
will hear you fully.
Yes.
We are not inclined to dismiss the
Yes.
petitions. Therefore, we wanted to,
2 minutes each
hear
side.
them.
My turn is
2
not,
minutes.
my turn is not even.
I will not take by the clock more than 2 minutes. Just 2 minutes, fellow, the Lordship will be shocked.
Turn 1 minute only. Your turn is over.
Let's understand what they have.
2 minutes, fellows, by the
1
clock.
minute, Millard, only. My turn is not even, Mr. Vanita Singh, others will also have.
1 minute, 1 minute.
No, no, you should, at some point of time, you should stop.
Appearing for a person who is not a writ petitioner.
Yes, yes,
He was
I'm a writ
not even
petitioner.
completed,
You
failed.
you don't know,
4 years.
I don't know whether my learned friend is aware for whom he is appearing. I am appearing for the writ petitioner.
2 minutes.
So, he may be having many clients, I have only one.
One sec. Lord, may I just say something?
Only one client.
Lord, may I,
Take one suggestion.
2 minutes, fellows, 2 minutes.
may I just say something?
But in fact, I couldn't open my mouth, so I am the petitioner. Not argue the matter in court below.
Fellows, 2 minutes by the clock.
We are rising for 10 minutes. We'll come back at 4:10 and we'll dictate a short order over here.
Kindly hear us.
Only one,
Our turn has not come.
issues
Sorry,
notice.
our turn has not
There
come.
would not be.
We were waiting for our turn.
Complete, my lord, that's the difficulty.
Sorry?
Issuance of notice, my lord, would ensure that service is not complete. It would never be heard, my lord. Therefore, that's my concern, my lord, as a lawyer, my lord, I'm.
We were,
Because there'll be too many parties to serve.
we were waiting for our turn. We were waiting for our turn. We are waiting.
Those who are waiting for the turn may be heard.
A lot of point which has not been made till now. Your lordship can order publication, my lord, this is not a.
Forget
Make service will
Well,
not.
I am saying 2 minutes. Give 2 minutes.
We'll direct publication because there's no question of individual service. And most important, we have sufficient representation of all different, a variety of
That's right.
interests here. Normally, in a matter like this, if people are unrepresented, there's an issue.
Yes.
We have adequate representation
Absolutely.
on both sides, including of a varied interest, so it's not an issue.
So allow 2
My
minutes.
category, I have not even been able to open
By
my
the
mouth.
clock, by the clock.
Give us time.
We have not argued, we're waiting in our queue.
All right, 1 second.
2 minutes
We'll
by
come
the
back in
clock.
exactly 10 minutes. Now tell us who remains to be.
I will not argue at all. I'll take 2 minutes.
I represent.
I'll take 2 minutes.
After vacation.
After vacation,
After vacation.
Please clock it at 2
The
minutes.
lordship be here is tomorrow. 5 minutes is all that it.
We'll take it up, we'll continue.
There's too much at stake.
Just 2 minutes.
Lord,
the interim order already passed, maybe
We'll take it up tomorrow.
Tomorrow, my lord?
We'll take it up tomorrow morning.
But my learned friend has given an order.
So we have already come, we have heard Mr. Pratik Dhar. We were following that order. Now the next, Mr. Rodgi was not well, so Mr. Madiyal has argued. Mr. Shyam Diwan has been.
Started.
Yes, Mr. Shyam Diwan is on his legs. We are going to have follow with Mr. Patwalia, Dr. Murlidhar, K. Parmeshwar, Mr. Dushan Dave, Mr. Giri, Dr. Singhvi, then
In item 27 and
then Mr. Amit Sharma, Siu Singh. Now, look, if everybody has to argue, we'll not even be able to finish.
Give us
tomorrow.
Just 5 minutes. 5 minutes, that's all.
There's no point in.
5 minutes.
Please fix it at 5 minutes. Please fix it at 5 minutes.
By the clock,
I would
5
not
minutes.
repeat any point. Just 2 minutes on a fresh point which has not been addressed.
2 minutes, I'll stop.
Limit
Just.
it to 2 to 5 minutes, whatever your lordship says.
For the purpose of deciding whether to dismiss the matter or whether to entertain the matter, we have heard enough. We have heard for a whole day. What we are proposing to do is,
We are on interim relief.
we are rising for 10 minutes. We'll come back and we'll dictate a small order after 10 minutes.
We'll get
1 minute.
I'll take your leave, my lord.
You still have.
No, not.